Okay, let's dive into something that it sounds a bit futuristic, but honestly, it's happening right now. Imagine this. A famous person passes away, right? But their identity, their face, their voice, their whole way of being it stays incredibly valuable. For years, this meant, licensing their image for posters, maybe using old film clips, putting their name on t-shirts. Pretty standard stuff. Classic legacy building. But here's where things have just totally shifted. Technology, and specifically AI, artificial intelligence, it's creating completely new ways to use and, well, potentially misuse a celebrity's name, image, and likeness, their NIL, long after they're gone. It's not just about showing old movies anymore. We're talking about potentially putting them in new movies, making them say things they never actually said or perform in ways they never did. It's creating this really complex challenge. How do you protect someone's legacy, their identity, in this, digital afterlife? And that's exactly what we're going to unpack today in this deep dive. How do these post-mortem NIL rights actually work? What are these new threats, particularly from AI and these digital replicas? And maybe most importantly, what can actually be done? Legally, technically, strategically, to protect that identity and make sure their wishes are honored. We've got a great stack of source material here that you, our listener, provided for us. It covers everything from the legal foundations to some really eye-opening case studies and the tech challenges. So our mission today is to guide you through all of this. We're going to pull out the most critical insights, maybe some surprising facts, and help you understand what's really at stake here and, how people are trying to deal with it. So let's start at the beginning. Build that foundation. What exactly are these rights we're talking about? How do they even stick around after someone dies? Let's bring in our expert.
Okay, so the absolute starting point is understanding the right of publicity. You hear it called NIL a lot now. Name, image, likeness. Essentially, it's the right, everyone has to control the commercial use of their identity. That means your name, your picture, your likeness, your voice, signature, even your whole persona if it's distinctive. And here's the really crucial distinction. It's not the same as the right of privacy.
Okay.
Your right to privacy, basically, a right to be left alone that generally dies with you. But the right of publicity, in many places, it's treated as a property right.
Property, like owning something.
Exactly. And just like other property, a house, stocks, whatever, can survive death. It can become part of your estate, be passed on to heirs, managed by trustees. That's a fundamental difference.
So it doesn't just vanish. It's an actual asset that can be passed down, like intellectual property.
Precisely. And you see that reflected in state laws. Many states that have created specific rights of publicity laws, especially more recently, have explicitly built in these post-mortem rights because they recognize that commercial value often continues, sometimes for decades.
Okay, that makes sense. But if it's property, is there one single law across the U.S. that covers it? Or is it more complicated than that?
Oh, if only it were that simple. No, there's no single federal right of publicity law. And this is where it gets really, really complex very quickly. It's truly a patchwork quilt of state laws. The protection you get varies dramatically depending on which state you're talking about. It might be based on a specific statute passed by the state legislature, or it might be based on common law, meaning judge-made law over time.
Patchwork quilt. Sounds messy.
It is, and the variations are huge. First off, not all states even recognize posthumous rights. Only about half, roughly 25 states do. And for those that do recognize it, the duration is all over the map. California protects it for 70 years after death.
70, okay.
Indiana goes for 100 years. Tennessee has this interesting model. It's 10 years, but then it can become perpetual if the right is commercially used during that initial decade.
Perpetual?
Yes, if used. Washington State is different again, 10 to 75 years, depending on the commercial value of death. The scope differs, too. Some states might just protect the basics, name, likeness. Others, like Indiana, are much broader. They explicitly include voice, signature, distinctive mannerisms, even appearance. And then there are other wrinkles. Some states used to require that the celebrity exploited their rights commercially during their lifetime for them to pass on, though that's less common now. And whether the law applies retroactively, meaning to people who died before the law was passed, that also varies. California is famous for going back to cover deaths from 1915 onwards if the identity had value.
That is mind-bogglingly complex. So if you have a celebrity who's known everywhere, how do you possibly figure out which state's law applies? It can't just be where they happen to be when they died, surely.
You've hit the absolute nail on the head. This is what's often called the domicile trap. Domicile isn't just where you live, it's your legal, permanent home, the place you intend to return to. And for most states that recognize these rights, the law of the state where the celebrity was domiciled at the moment of their death is the critical one. That state's law determines if the right of publicity exists at all for that person posthumously, what its scope is, how long it lasts, and who legally inherits or controls it.
Domicile. Okay, that's the key.
It is. And the classic cautionary tale here is the Marilyn Monroe estate battle. It went on for decades. Her estate struggled for years to assert publicity rights, partly because they had previously argued, for tax reasons, that her domicile was New York.
Ah.
And at that time, New York law didn't recognize a descendable right of publicity. Later, California passed its strong retroactive law, which would have helped. But the estate couldn't easily claim California domicile because of those earlier inconsistent positions they'd taken for tax purposes.
So they were stuck.
Pretty much. It just starkly highlighted how crucial domicile is, and how taking inconsistent legal positions can completely undermine these rights. Now, it's true that a few states, like Illinois or Indiana, have laws that might also kick in if the unauthorized use, the infringement, actually happens within their state borders, regardless of the celebrity's domicile. But that domicile state's law, it's still the absolute foundation because it determines if the property right exists in the first place to even be infringed upon.
Wow. Okay. So understanding and maybe even strategically planning domicile during life is absolutely critical, just laying the groundwork that sets the stage for the right itself. But now, AI. You mentioned AI. How are these new technologies really changing the game and, I guess, threatening this asset?
Right. This is where things get really challenging for the traditional legal framework. AI, artificial intelligence, it enables the creation of these incredibly realistic, digital replicas or deepfakes.
Digital replicas, deepfakes, okay.
Yeah, and it helps to be clear on the terms, like your sources define them.
Mm-hmm.
A digital replica is basically a newly created electronic likeness. It could be a voice, an image generated by AI or some other tech. The key is the person didn't actually perform it, but it's designed to look or sound authentic. State laws defining this often stress that it's hard, maybe impossible, for a reasonable person to tell it's not the real person.
Okay, indistinguishable.
Pretty much.
Yeah.
Then a deepfake is often used to describe a specific method, usually using deep learning AI to maybe superimpose someone's likeness onto another video or to create entirely new, synthetic but highly realistic depictions, visuals, voice, even characteristic mannerisms. And then AI-generated likeness is sort of the umbrella term. It covers any depiction of someone's identity created using AI. Could be a replica, a deepfake, a voice clone. The main thing is the capability now and the increasing accessibility of this tech to create these convincing representations. That's the core threat.
Okay, so they look real, they sound real, but what are the actual, tangible dangers this poses to someone's legacy after they're gone?
Oh, the threats are pretty significant, and they come in a few flavors. First, there's just blatant, unauthorized commercial exploitation. Imagine seeing a deceased icon suddenly appearing in new commercials they never would have approved. Or maybe starring in new movies or recording new songs, all generated by AI without the estate's permission.
Right, using their image to sell stuff they never agreed to.
Exactly. Second, and this one feels maybe even more worrying, is the potential for misinformation and damaging their reputation. AI could be used to make it look like a deceased celebrity is endorsing political views they hated, or saying things totally out of character, contradicting their known values, or even depict them doing things that tarnish their legacy. That can undo decades of carefully built reputation.
Yeah, that's scary.
Third is just the sheer accessibility of the tech now. This isn't just limited to huge Hollywood studios with massive budgets anymore. Deepfake tools, AI voice cloning, it's becoming much more widely available. That makes it incredibly hard to track down and stop unauthorized uses, especially globally. And there's another kind of subtle challenge, especially for celebrities who lived a long life. AI can realistically de-age them.
De-age them?
Yeah, make them look perpetually young in new content. Now, that might have some commercial appeal, sure, but it also risks freezing their public image at just one point in time, maybe overshadowing their full career, their later work, their evolution as a person. It's a bit different for stars who died young, like James Dean or Marilyn Monroe, who are already kind of fixed in time as youthful icons. AI can now potentially manufacture that perpetual youth for anyone, regardless of how long they lived.
It really sounds like the tech is just sprinting ahead and the law is sort of jogging to catch up. How are the laws reacting to the speed?
They are reacting, but jogging is probably a good word for it. It's definitely a scramble, and it's happening primarily state by state, piece by piece.
So, still that patchwork.
Still that patchwork. We're seeing specific legislative efforts pop up. California, for example, amended its main right of publicity statute, Section 3344.1, the Astaire Act, to specifically address digital replicas, especially how they're used in expressive works like movies or songs. Though there are exceptions for news, documentaries, things like that. New York passed Section 50F, which offers some protection against digital replicas for deceased performers, but it's quite limited. It mainly applies to scripted AV works or music, only if the use is deceptive.
Deceptive.
Right, and here's the controversial part. It allows a simple disclaimer saying it's AI as a potential defense. Many critics argue that's just a legal fig leaf. It might technically comply with the law, but doesn't actually stop public confusion or protect the legacy.
A disclaimer might not be enough.
Exactly. New York also passed a separate law, Section 5302, dealing with AI and living performers contracts, which signals the broader concern but doesn't directly help the deceased issue much. Illinois is taking a stronger step with changes effective January 1st, 2025. Their law will explicitly define and prohibit the unauthorized commercial use of both identity and digital replicas. And Tennessee just passed the LVIS Act in 2024, specifically targeting AI misuse of voice and likeness. So states are definitely trying.
But it sounds like there are still big challenges.
Oh, absolutely. The tech just moves so fast, it's incredibly hard for laws written today to anticipate what AI will be able to do tomorrow. And there's this fundamental consent paradox. How could someone who died 20, 30 years ago possibly have given meaningful consent to having their likeness used by technology that didn't even exist then or that they couldn't possibly have understood?
Yeah, you can't consent to the unknown.
Right. And as we mentioned with New York, defenses like a small disclaimer might provide legal cover, but do little to prevent actual brand dilution or public deception.
Beyond just the legal hurdles, does this raise bigger ethical questions?
Profound ones, I think. Can you really get meaningful consent posthumously for uses of someone's identity via technologies that were completely unforeseen? It puts fiduciaries, executors, trustees in a terrible position. They're left guessing intentions without clear guidance. There's a very real risk of exploiting someone's death purely for financial gain, potentially flying in the face of everything they stood for or explicitly wished against.
That feels uncomfortable.
It does. And then there's the whole uncanny valley aspect. Even when AI replicas are technically flawless, they can often feel creepy, unsettling, inauthentic. The power to make a deceased person appear to say or do things they never would, endorse products, support causes, utter phrases that feels like a serious ethical breach of their authentic reputation. And AI really pushes the boundaries of traditional rights of publicity law, especially around that commercial use requirement. What if someone creates an AI deepfake but claims it's transformative art or satire or parody? They might try to argue it's protected by the First Amendment, even if it clearly uses a recognizable likeness to make money or gain attention.
Right. The line between art and infringement gets blurry.
Exactly. State laws often have exemptions for expressive works, news reporting, parody, etc. But AI makes drawing that line, figuring out where protected creative expression ends and infringing commercial exploitation begins much, much harder.
Okay, it really does sound like a minefield. Legal questions, ethical dilemmas. So what can someone actually do? If you're a celebrity or devising one, how do you try and navigate this during your lifetime to protect that legacy?
This is where proactive planning becomes absolutely essential. It is, without a doubt, the single most powerful defense available. You have to start thinking about this while the person is alive and can make their wishes known.
So, estate planning.
Yes, but not just any estate planning. Wills and trusts are the cornerstone, absolutely. But just relying on standard boilerplate language about assets, that's completely inadequate for something as valuable and complex as NIL rights today, especially with AI in the mix. You need specific, detailed instructions. Remember, we established that the right of publicity is property in many states, so it can be controlled, transferred, and managed through these estate planning documents.
Specific instructions are key.
Absolutely. The trust set up by Robin Williams before his death is often cited as a prime example of good planning here. Reports say he included a 25-year restriction on anyone exploiting his publicity rights after his death, and he apparently went further, explicitly prohibiting the use of holograms or inserting his likeness via CGI into new performances.
Wow, he actually anticipated things like holograms.
It seems so. That level of foresight, that precision in anticipating specific types of technology, really shows the power of a carefully drafted plan. It gives clear direction. And nowadays, including a distinct clause specifically addressing digital assets, including NIL and AI likenesses, is becoming vital.
Makes sense.
But here's another critical point. These plans cannot be static. You can't just draft it once and forget about it. They need much more frequent review and updating than, say, a traditional plan dealing only with houses and bank accounts.
Why are we frequent?
Because the technology is changing so incredibly fast, and the laws are constantly trying to catch up. A plan drafted even 5 years ago might not adequately address the AI capabilities we see today. Your sources mentioned examples like Philip Seymour Hoffman or Heath Ledger, whose wills reportedly weren't updated after major life events like having children, leading to unintended consequences. That risk is amplified massively when you're dealing with dynamic, evolving digital rights like NIL in the age of AI.
So keep it current. What kind of specific language should someone push their lawyers to include in these documents to really tackle this AI challenge head on?
It needs to be extremely meticulous and frankly forward-thinking. First, you need to clearly define the scope of the rights being managed. Don't just say name and likeness. Explicitly list name, image, likeness, voice, signature, persona, mannerisms. And then this is crucial. Explicitly define and include things like digital replicas, AI-generated likenesses, deepfakes, voice clones, and maybe even use broad language to try and capture future technologies capable of replicating identity that we can't even conceive of yet.
Cover all the bases, known and unknown.
Try to, yes. Second, you need to state explicit wishes about posthumous use. Do you want to permit any use? Do you want to restrict it heavily? Maybe only for documentaries or restorative context. Or do you want to prohibit all posthumous commercial use, especially AI-generated uses? Be specific. No endorsements, no political affiliations, no use in certain types of content, like violent films maybe. And clearly define who gets to make the judgment call. Call as your executor. A specific trustee. A designated committee of trusted advisors.
Okay, spell it out.
Spell it out. Third, address AI and digital replicas directly. Don't leave it ambiguous. Either completely prohibit their creation and use, or, if you're open to it, allow them only under very narrow, strictly controlled conditions. Maybe require unanimous approval from a specific group of fiduciaries who deeply understand your values and brand. Fourth, grant specific, broad powers to your fiduciaries. Give your executors and trustees clear legal authority not just to manage assets, but specifically to manage, license, protect, and litigate these NIL rights. Include the explicit power to sue over unauthorized AI uses.
Give them the tools they need.
Exactly. And fifth, consider a statement of wishes. This is usually a separate, non-binding letter. It can be helpful to guide your fiduciaries on more subjective matters or scenarios you couldn't explicitly cover in the binding legal documents, but use it consciously. It must not contradict the legally binding terms in your will or trust. If it does, your fiduciaries might be legally obligated to follow the formal document, even if it goes against your letter. The Princess Diana estate reportedly faced issues with this.
So guidance, but not conflicting guidance.
Precisely. Beyond the core will or trust, you might also look at specialized trusts, sometimes called a name and likeness trust or an IP trust. These can be really beneficial. They let you centralize the management of these complex rights under a trustee who hopefully has specific expertise. They offer more flexibility than a will might. They keep the details private, unlike a will which becomes public record. And they can offer potential tax planning advantages, especially if set up as irrevocable trusts during your lifetime. You can even structure them as directed trusts, where the main trustee is legally required to follow the guidance of specialist advisors you appoint, say, an entertainment lawyer or an AI expert specifically on NIL matters.
Interesting. That leads to the fiduciaries themselves, the executors, the trustees. It sounds like they have a really tough job here.
Incredibly tough. They're caught in this potential conflict. Balancing the desire to generate revenue for the estate or beneficiaries, which might involve licensing an AI digital replica, against respecting the deceased's likely wishes, maintaining authenticity, and avoiding public backlash.
Yeah, that authorized but unpopular issue you mentioned with James Dean.
Exactly. If the planning documents don't give them clear guidance, they're forced to guess your intentions. That's a recipe for bad decisions, PR disasters, or even damaging legal fights among heirs or between heirs and the fiduciaries. Some state laws try to provide guardrails. Illinois law apparently requires fiduciaries act in good faith, considering the deceased's likely wishes. New York allows 51% of the interest holders to make certain decisions, but clear, specific instructions from the celebrity in the planning documents are absolutely irreplaceable.
So choosing those fiduciaries must be just as critical as drafting the documents themselves. How do you pick the right people for such a sensitive job?
Oh, absolutely vital. It's not just about picking someone you trust, although that's paramount. You also need people who either understand the complexities of NIL rights, the specific industry like entertainment or sports, and crucially, the celebrity's personal values. Or, if they don't have that expertise themselves, they need to be capable and willing to seek out and rely on expert advice.
So knowledge or the wisdom to get knowledge.
Yes. Consider appointing specialized co-fiduciaries. Maybe one family member handles personal matters, and an experienced entertainment lawyer or business manager handles the NIL assets as a co-trustee, or appoint specialist advisors. There's some talk about needing a digital executor for things like social media accounts, but AI itself can't fill the role of a legal executor or trustee. Fiduciary duty requires human judgment, accountability, and legal personhood. AI isn't there. The absolute key, though, is giving whoever you choose a clear mandate and the necessary powers within the estate planning documents.
Okay, so the plan is drafted, the right people are chosen. How do these NIL rights actually get transferred and managed legally after the person passes away?
The rights transfer according to the mechanisms laid out in that estate plan. Usually it's through testamentary transfers, meaning instructions in a will or, more commonly for complex assets, a trust. These documents direct who inherits the rights or the income generated from them. Alternatively, some people use lifetime transfers. They might move ownership of their NIL rights into an irrevocable trust, or perhaps a private foundation while they're still alive, often for tax planning or asset protection reasons. Licensing is also key. Any licensing deals made during life need careful review, and any new licenses granted by the estate must meticulously address post-mortem use and, now, specifically AI. If the rights end up being owned by multiple beneficiaries, say, several children, the estate plan needs robust management structures. You need mechanisms to prevent deadlock where heirs can't agree on licensing decisions. This might mean designating a single manager, setting rules for majority voting on specific issues, or maybe even putting the rights into an LLC managed by a professional. Lessons from states like Illinois or New York, which has statutory rules for managing jointly owned ROP, can be instructive here.
Seems like a lot to juggle.
It is, and we haven't even touched much on the huge challenge of valuation. These posthumous NIL rights can be incredibly valuable assets, but figuring out how valuable for estate tax purposes, that's extremely complex and subjective.
How do you put a price tag on potential future AI uses?
Exactly. It's highly speculative. How do you value the potential for an AI replica to star in movies that haven't even been conceived yet? It's a major headache and often leads to disputes with tax authorities like the IRS.
Okay, one more piece on the legal mechanics. Is there anything official, like you can file with the state to put the world on notice about who controls these rights after death?
Yes, and in some key states, this is a really important procedural step: registration. States like California and New York have systems where the person or entity who inherits the right of publicity, the successor in interest, can formally register their claim with the Secretary of State.
And what does that do?
It primarily serves as public notice. It tells the world, hey, we are the ones who legally control this deceased celebrity's NIL rights. But, crucially, in both California and New York, there's a significant enforcement consequence. You generally cannot recover monetary damages for any unauthorized uses of the NIL that occurred before you officially registered your claim.
Oh, wow. So if someone uses the likeness before you register, you might be able to stop them, but you can't get paid for that past use.
That's generally the rule in those states. So while registration doesn't create the underlying right that comes from the law and the estate plan, it's absolutely essential for effective enforcement and being able to recover financially if infringement happens. It's a vital box to tick.
It really drives home how different the rules are state by state. That legal landscape sounds treacherous. Could we maybe just zoom in on a couple of those key states to really hammer home how varied it gets?
Absolutely. Understanding the specifics is critical because of that patchwork nature. Where the celebrity was domiciled, where the infringement occurs, it all matters. So let's look at California. Their law is Civil Code Section 3044.1, often called the Astaire Act. It's known for being quite extensive. Protection lasts 70 years post-death. It's retroactive back to 1915, provided the identity had commercial value then. Generally, California domicile at death is needed for the rights to pass under their specific statute, but the law also applies if someone infringes the right within California, regardless of the celebrity's domicile.
Okay, broad reach within the state.
Yes. And remember, registration is required to get damages for uses that happened before you registered. California has also specifically added provisions about digital replicas. They target the use of these replicas in expressive works, like movies or songs, unless the estate consents. There are exceptions, like for news or documentaries if they aren't misleadingly sponsored. The definition of digital replica focuses on whether it's readily distinguishable from the real person. That whole expressive works exemption area is really complex and frequently litigated. Where does creative freedom end and infringing commercial use of an AI likeness begin? It's a tough line.
Okay, California. Long duration, retroactive, digital replica rules, registration needed for damages. Got it. What about New York?
New York is quite different. The key thing to remember is New York has no common law right of publicity. It's all based on statute, primarily Civil Rights Law, Section 53, for the post-mortem rights relevant here. Their post-mortem rights last 40 years, but a lot of the key provisions only applied to deaths occurring after May 2021. And you must have been a New York domiciliary at death for these rights to pass under their statute. Like California, they have a registration system. And again, you generally can't get damages for pre-registration uses.
So shorter duration, not retroactive in the same way. Domicile is key.
Right. And for AI, New York Section 53 gives specific digital replica protection, but only for deceased performers, and only in pretty narrow contexts. Like if the replica is used in a scripted audiovisual work portraying them as a fictional character or in a live musical performance context. And critically, liability often hinges on whether the use is deceptive. And this is where that controversial disclaimer defense comes in. If there's a conspicuous disclaimer stating it's not the real performer, that could potentially shield the user from liability under this specific section.
Even if people are still confused.
Potentially, yes. Critics argue it prioritizes legal compliance over actual legacy protection. It's worth noting, New York did pass a new law, General Obligations Law, Section 5302, starting in 2025, that regulates AI use in living performers contracts, showing the legislature is concerned, but it doesn't directly change the Section 54 rules for deceased performers.
Okay, New York, statutory only, shorter term, domicile required, registration needed, narrow AI rules with that disclaimer defense. What about somewhere like Illinois?
Illinois offers 50 years of post-mortem protection for identity under its Right of Publicity Act, 71065 ILCS 2075. One big difference from California and New York is that Illinois doesn't seem to have that strict domicile requirement for the right to apply. Their law can be triggered if the unauthorized use happens within Illinois.
So use in the state matters more than domicile there.
It appears so, yes. The source materials don't mention a registration requirement for Illinois like in CA or NY. But here's the big news for Illinois. Amendments effective January 1st, 2025 specifically address AI. They explicitly defined digital replica and generative AI and make it illegal to use a deceased individual's identity or their digital replica for commercial purposes without authorization.
So they're tackling AI head-on now, too.
Yes, quite directly. The law includes standard exemptions for things like news, parody, and art, and also has safe harbor provisions for online service providers under certain conditions. And just as another quick example, remember Tennessee passed the LVS Act in 2024. That's another state specifically crafting new legislation to target AI misuse of voice and likeness, driven partly by concerns in the music industry there.
Wow. The differences are just stark. Domicile rules, definitions, liability standards, defenses. It really highlights the complexity.
It absolutely does. And the uncertainty created by this patchwork really strengthens the arguments you hear from some quarters for uniform federal right of publicity law, though that faces its own hurdles.
Okay, so we've got the foundational estate planning documents, and we understand this crazy quilt of state laws is crucial. Are there other layers of protection someone can put in place beyond just the legal paperwork?
Yes, definitely. You really need to think multi-layered. Technology itself and smart contracts can add important safeguards.
Technology protecting against technology.
Sort of, yeah. One technique being discussed and developed is digital watermarking. The idea is to embed hidden data directly into digital content images, audio files, videos. This data could signify things like the origin of the content, confirm its authenticity, or maybe even include a marker explicitly stating it was generated by AI.
So you could tell if a video is real or fake.
Potentially, yes. Or at least tell if an authorized piece of content is genuine. It could help verify authorized originals and maybe trace unauthorized fakes back to a source. Some AI tools are already starting to embed metadata automatically. Proactively watermarking your own authorized photos, recordings, etc. could be a smart defensive step.
But is it foolproof?
Oh, definitely not. Watermarks aren't magic. Determined infringers can often find ways to remove or degrade them. For it to be truly effective, you'd need widespread adoption and standardization across all creation tools, editing software, and online platforms, and we're certainly not there yet. It's kind of an ongoing arms race. As watermarking tech gets better, AI tools to remove them also improve. So while it's a valuable component and something regulators like the EU with its AI Act are looking at, it's not a standalone solution, just one piece of the puzzle.
Okay, so watermarking helps, but isn't perfect. What about contracts?
Contracts are absolutely critical, specifically the licensing and contractual agreements made during the celebrity's lifetime. Anyone with valuable NIL needs to manage their contracts with extreme care, thinking long-term. Existing contracts need to be reviewed. Do they inadvertently grant away rights related to future technologies or post-mortem use? And any new contracts must explicitly address these issues.
What should those contracts say?
They need to be meticulously clear. Define the exact scope of use allowed, the duration, the compensation, and specifically how the NIL can or cannot be used after death. And crucially, they need to address AI and digital replicas directly. Don't leave it vague. You can explicitly prohibit their creation or use altogether within the scope of that contract. Or you could permit them, but only under very strict conditions, perhaps requiring specific approval from the estate for each use. Define very narrow, acceptable uses if you go that route.
Avoid those generic clauses.
Absolutely. Avoid those overly broad standard clauses you sometimes see, like granting rights in all media now known or hereafter devised, unless you add specific carve-outs or controls for AI-generated uses. You might even consider specific time limits on any AI-related licenses or prohibit certain types of AI use that feel particularly exploitative or off-brand.
Be very specific about AI.
Very specific. And think about that Bruce Willis example again. Your sources mentioned he reportedly licensed his likeness proactively to a deepfake company for future use. There wasn't just defense, it was almost an offensive strategy. Taking control, participating in the space on his terms, potentially preempting crappy unauthorized deepfakes by having a high-quality authorized version available that meets certain standards and aligns with his image. It's a different way to think about maintaining control.
That's interesting. What about industry groups, like actors' unions? Do they play a role in setting standards or pushing for protections here?
Oh, a huge role. Guilds and unions, especially SAG-AFTRA for performers in the U.S., are vital advocates. They use their collective bargaining power negotiating union contracts with studios and employers to hammer out terms that address AI. They fight for things like requiring explicit performer consent before a digital replica can be created or used, putting limits on how AI can be used, trying to prevent it from simply replacing live actors, ensuring fair compensation when a likeness is used, whether real or digital, demanding transparency from employers about when and how AI is being used, and protecting actors' past performances from being scraped without permission to train AI models.
So they're fighting on the front lines in contract talks.
Exactly. And they also engage heavily in legislative advocacy. SAG-AFTRA, for instance, might lobby for stronger state laws or support federal bills, like the proposed AI Copyright Transparency Act in California that would require companies to disclose what copyrighted works they use to train their AI models.
How much influence do they really have, especially for deceased performers who aren't members anymore?
Their influence is significant, even indirectly. While their primary focus is protecting living, working members, the standards they set in those widely used industry contracts create important precedents. They establish ethical baselines for the entire entertainment industry. And those standards inform public perception and can influence how judges view these issues when estates do bring lawsuits against unauthorized AI uses. If an estate can argue that a particular use violates established industry norms fought for by the union, that can strengthen their case about unfairness or exploitation.
Okay, so we've got planning, state laws, tech tools, contracts, unions. But let's say, despite all that, someone does create an unauthorized deepfake or AI replica and starts using it commercially. How does the estate actually fight back legally? What are the options?
Right, enforcement is key. Even with the best plans, unauthorized uses will happen, especially with how fast things spread online. Estates need to know their legal arsenal. The primary legal avenues usually start with bringing a right of publicity, RP claim, under the relevant state law we discussed, arguing unauthorized commercial use of the identity. But there are other tools. Federal law offers the Lanham Act, Section 43A, which prohibits false endorsement. If an AI use is so realistic that it's likely to confuse consumers into thinking the deceased celebrity or their estate sponsored or approved the product or service, that could be a federal claim. This becomes increasingly relevant with hyper-realistic deepfakes, as a celebrity's persona often functions as a brand identifier even after death.
So if it looks like they're endorsing something they aren't.
Exactly. Beyond that, estates might use state unfair competition or consumer protection laws if the use is misleading or deceptive to the public. Copyright infringement could be relevant if the AI used copyrighted photos, videos, or recordings as source material, although the law around AI training data is still very much developing and complex. It's distinct from the ROP claim, which protects the identity itself. If there was a contract involved and the licensee violated its terms regarding AI use, then a breach of contract lawsuit is possible. And importantly, estates can now potentially sue directly under those new digital replica statutes being enacted in states like California, New York, Illinois, and Tennessee. These laws are specifically designed to target the misuse of AI-generated likenesses.
Lots of potential claims. Is it easy to enforce, though?
That's the practical challenge.
Okay.
As you suggested, AI content can spread incredibly fast online across multiple platforms, often anonymously. Actually stopping it can feel like playing that frustrating game of whack-a-mole. You get one taken down, two more pop-ups. It's a constant battle.
Okay, so let's say the estate manages to sue and they actually win in court. What can the court do? What are the possible remedies?
Courts have a range of remedies they can order. They can award actual damages, which means trying to calculate the real financial harm the estate suffered, maybe lost licensing opportunities because of the unauthorized use, or damage to the brand's value. They can also order the infringer to pay over their infringer's profits, basically, making them give back the money they made from illegally using the likeness.
Oh, okay, getting the money back.
Yes. But proving actual damages or the infringer's exact profits can be really difficult, especially with online uses. That's where statutory damages come in, if the relevant state law allows them. These are fixed amounts set by the statute for each violation, regardless of the actual proven loss. California's ROP law, for example, allows at least $750 per unauthorized use. New York sets a minimum of $2,000. Statutory damages can be a much stronger deterrent, especially against infringers who might think the estate can't easily prove financial harm from hard-to-trace AI uses.
So a guaranteed penalty.
In effect, yes, if liability is found. Courts might also award punitive damages in particularly bad cases, meant to punish willful or malicious infringement, not just compensate the estate. But often, for an estate focused on protecting the legacy, the single most important remedy is injunctive relief.
An injunction.
Yes, that's a court order telling the infringer to stop the unauthorized use immediately and permanently. Preventing further harm to the reputation and controlling the narrative is frequently the estate's primary goal, sometimes even more than monetary damages. And finally, in some jurisdictions like California, the winning party in an ROP lawsuit might be able to recover their attorney's fees and costs from the loser, which can be substantial.
That makes sense. But what about enforcing these rights or even just starting the lawsuit if the person doing the infringing is in the same state or even in the same country? That must be a nightmare.
It is a major, major hurdle, cross-jurisdictional enforcement. The internet obviously has no borders, but legal systems absolutely do. First, you run into complicated choice of law issues. If an infringing website is based in Delaware, hosted in Ireland, but viewed by people in California, which state's right of publicity law even applies, it gets messy fast. Second, you face personal jurisdiction problems. Can a court in California legally force a defendant who lives and operates entirely in, say, Florida or Germany to show up and defend a lawsuit in California? It depends on their minimum contacts with the state, which can be hard to establish for online activity.
So you might not even be able to sue them where you want to.
Exactly. And even if you do get a judgment, say, a California court orders a German company to pay damages, actually enforcing that judgment in Germany can be incredibly difficult and depends on international treaties and German law. The ongoing lack of federal uniformity in U.S. right of publicity law just makes all of this harder for estates trying to protect a nationally or internationally recognized figure. It fuels those calls for a single federal standard. And then there's the very practical barrier, the anonymity the internet can provide. Sometimes it's incredibly difficult just to figure out who is behind the infringing website or deepfake video in the first place, let alone where they are located.
Wow. Yeah, the global nature of this really adds layers of complexity. Let's maybe circle back to some of those real-world examples we touched on earlier. Seeing how these issues played out in practice might help crystallize some lessons.
Definitely. Revisiting those cases really illuminates the principles we've been discussing. Take the Marilyn Monroe estate again. The key lesson there, as we discussed, is the absolute paramount importance of domicile. The estate's prior, potentially inconsistent claims about her legal residence for tax purposes became a massive obstacle. It ultimately hampered their ability to fully benefit from California's strong retroactive ROP law. The outcome hinged almost entirely on that technical legal question of domicile at death, not just her fame or where she worked.
Domicile, domicile, domicile. Got it.
Then look at Robin Williams. His case highlights the immense power of specific proactive planning in a will or trust. Those reported directives explicitly anticipating technologies like holograms and CGI and putting a 25-year restriction on exploiting his likeness showed remarkable foresight. It gave his estate clear instructions and maintained a significant degree of control after his death. It stands in stark contrast to situations where such specific guidance was lacking, like the controversies that erupted over the proposed Prince hologram performance a few years ago.
Right, clear instructions matter.
Hugely. Although, it's worth noting, as your sources point out, that even Williams's otherwise well-drafted plan reportedly had some ambiguities concerning tangible personal property, which led to disputes. It just reinforces the need for comprehensive clarity across all types of assets, including NIL.
Okay. What about the more recent incidents involving actual AI-generated likenesses?
Right, the James Dean digital casting in a new film is incredibly telling. Even though his estate authorized it, the decision sparked enormous public backlash and intense ethical debate about resurrecting deceased actors. It perfectly illustrates that authorized but unpopular dilemma we talked about. Just because the estate gives legal consent doesn't mean the public will accept it, and it can still potentially harm the legacy's value through negative perception. It really underscores the need for fiduciaries, guided by clear directives to consider not just legality, but public reaction and the celebrity's likely values.
Consent isn't everything.
Not always, no. The Robert Kardashian hologram, while intended as a personal gift, not a commercial use, vividly demonstrated AI's power to create entirely new posthumous performances. It raises questions about how easily a deceased person's perceived actions or statements could be manipulated if that technology were used commercially, without extremely strict controls and oversight based on their wishes. And we can look back at slightly earlier examples, like the digital recreations of Carrie Fisher or Peter Cushing in Star Wars films, or Paul Walker in the Fast and Furious franchise. Those often involved more traditional CGI rather than pure AI deepfakes, and typically happened with close cooperation between the estate and the studio. But they paved the way, technologically and ethically. The lesson from all these is that AI now makes digital resurrection far more feasible and accessible. But the line between a respectful tribute and potential exploitation is incredibly fine and subjective. Estate consent helps, but it doesn't eliminate the risks or the need for clear directives from the individual themselves.
It seems like the foundational planning is just non-negotiable.
Absolutely. And we can draw crucial lessons even from broader celebrity estate battles that weren't solely about NIL, but highlight the essential groundwork. Think about cases like Aretha Franklin, Prince, or Sonny Bono, who reportedly died without formal or updated wills. The result was chaos, massive legal expense, and outcomes potentially very different from what they would have wanted. That kind of chaos is magnified exponentially when you throw complex, high-value NIL assets and rapidly changing AI technology into the mix. Getting the basic estate planning right, a clear, valid will or trust, is the absolute prerequisite.
Get the basics right first.
Always. Then you have cases like Philip Seymour Hoffman or Heath Ledger, whose wills reportedly weren't updated after having children. That tragically illustrates the danger of not reviewing and updating plans regularly as life circumstances change. The contest over Lisa Marie Presley's trust amendment reportedly involved questions about whether the proper legal formalities were followed. That underscores how critical it is to execute these documents correctly according to state law so they actually hold up. And on the flip side, you have someone like James Earl Jones, who reportedly engaged in specific planning around his digital assets and iconic voice, showing the kind of foresight that is now becoming essential for anyone with valuable NIL.
Right.
So taken together, all these cases hammer home the same point. Comprehensive, clear, correctly executed, and regularly updated estate planning isn't just a nice-to-have. It's absolutely indispensable for protecting a celebrity's identity and legacy in this challenging new era.
This has been incredibly insightful. It's so clear. This isn't some distant future problem. It's here now. It's complex, and the stakes are really high. So let's try to bring it all together. Based on everything we've discussed, what are the absolute key strategic recommendations? If you're a celebrity or advising one today, what's the action plan? What should they do?
It really demands a multi-layered, proactive strategy. You almost need to think about building a complete legacy ecosystem to protect the identity. So if we were to summarize it into a kind of checklist based on the source material in our conversation, it would look something like this. First, focus intensely on the legal and estate planning foundation. Get expert legal counsel now, and not just any estate lawyer, but someone who truly understands right of publicity, intellectual property, and the implications of AI law. Conduct a rigorous domicile analysis. Figure out which state's laws are most favorable regarding ROP duration, scope, AI provisions, lifetime use rules, etc., and make a strategic decision about establishing domicile there, balancing it with other personal and financial factors. Then, draft, or more likely, update your wills and trusts. They must explicitly cover all forms of NIL, define everything clearly, and include detailed definitions and specific directives about digital replicas, AI-generated likenesses, and future tech. Be crystal clear. What's allowed, what's restricted, what's prohibited. Seriously, consider using a dedicated NIL trust or IP trust for centralized management, privacy, and potential tax benefits. Ensure all documents are executed with strict adherence to legal formalities so they're valid. And critically, review and update frequently. At least every 3 to 5 years is a good guideline, but do it sooner if there are major life events, marriage, kids, significant legal changes in relevant states, or major new technological breakthroughs you need to address. Once the estate is active, register the ROP rights where possible and required for damages, like in California or New York, and make sure all this NIL planning is integrated with your overall tax planning.
Okay, get the legal house in meticulous order and keep it updated. What's next?
Second layer, contractual and licensing practices during lifetime. You need to be vigilant about contracts. Review all your existing agreements, endorsements, film contracts, recording deals. Check for clauses about post-mortem rights or broad grants that might cover future tech like AI. When negotiating new contracts, make them future-proof. That means explicitly addressing AI and digital replicas. Define exactly what uses are permitted, if any. Set clear limits. Insist on approval rights for any AI-generated use of your likeness. Absolutely resist signing overly broad, all media now known or hereafter devised clauses without specific protective carve-outs for AI.
Control the contracts. Got it. Layer 3.
Third, leverage technology and monitoring. Investigate using digital watermarking on your own authorized photos, videos, and recordings to help establish authenticity later. Just remember its limitations. Set up a robust system for posthumous monitoring online to detect and flag unauthorized uses of your NIL quickly after your death. You need eyes and ears online.
Use tech against tech and monitor. Makes sense.
Fourth is fiduciary selection and guidance. This is so important. Choose your executors and trustees with extreme care. Yes, trustworthiness is key, but they also need to understand or be capable of learning about and taking advice on NIL, your specific industry, your values, and the tech landscape. Give them clear, unambiguous directives in the legal documents. That's paramount. A supplementary letter of wishes can provide helpful context for subjective decisions, but again, ensure it doesn't conflict with the binding will or trust.
Choose wisely. Guide clearly. Anything else?
Fifth, engage in advocacy and awareness. Support the efforts of industry groups like your relevant guild or union that are actively negotiating for stronger AI protections in contracts and lobbying for better laws. And personally, stay informed about legislative proposals and changes happening at both the state and federal levels. This landscape is shifting constantly.
Stay engaged.
And just to hammer home the domicile point, again, it requires careful analysis and strategic planning. It's not just about where you like to live, it's a legal decision with major consequences for your legacy rights. Ultimately, the overarching theme is the need for staying ahead of tech and legal developments. This requires continuous learning, consulting with experts regularly, and viewing your legacy protection strategy as dynamic and adaptable, not a one-time fix. And perhaps consider that proactive offensive strategy idea, like Bruce Willis. Selectively licensing certain AI uses under your strict control might be a way to shape the narrative, set quality standards, and potentially preempt unauthorized low-quality uses.
Wow. Okay. This deep dive has certainly made it crystal clear just how significant and, frankly, how complex the threat AI poses to a celebrity's identity and legacy after they're gone.
It really is a profound challenge. But the key takeaway, I hope, for you, the listener, is that while the threats are very real and constantly evolving, the single most powerful tool available is that proactive, informed, and truly comprehensive planning done during the person's lifetime. That means having those strong estate planning documents with explicit directives covering new tech, like AI. It means careful fiduciary selection and providing clear guidance. It involves negotiating smart, future-proof contracts during life. It requires staying updated on that complicated state-by-state legal map and understanding the tools available for enforcement if needed.
Ultimately, like you said earlier, this is fundamentally about control, isn't it? It's about doing everything possible to ensure that a lifetime's work, that unique persona, is preserved, is represented authentically with dignity, and is used, or maybe just as importantly, not used according to their actual wishes, long after they're no longer here to voice them. This whole deep dive into protecting a legacy in the age of AI, it definitely raises some fascinating questions for all of us to think about. How do you think about that ethical balancing act between the undeniable potential for financial gain using technology like AI to recreate someone's likeness and the fundamental importance of maintaining authenticity and dignity for someone who can no longer consent or speak for themselves? Something to ponder.